Hi there, this is Samantha from the law offices of Samantha Wolfe. And you can reach us at 717-655-2676. Our office is located at 20 East 6th Street in Suite 206 in Waynesboro, PA. And this video is actually a hypothetical. I did hypothetical number 1, and this is hypothetical number 2, explaining how trust can be used to provide an asset protection plan and for an estate plan for clients. And it's designed to be watched along with the What's in Your Closet taping that I did. And that provided an overview of this type of planning and kind of the substantive material that would be helpful to know. And then this is designed to illustrate that. So if you haven't already watched those, I would encourage you to go back and do that. This is a hypothetical, again, just designed to give you an example and show you what our office can do. Okay, so let me share my screen here. Okay, so this is situation number 2. So we have Mike and Carol Brady, both in their 60s. They married in 2009. So they've been married for a decent amount of time. And Mike is a well-paid physician and Carol is an attorney. This was the second marriage for both of them. Mike has 3 sons. You're probably never going to guess their names. Greg, Peter, and Bobby. And Carol has 3 daughters, Marcia, Jane, and Cindy. And they both have excellent long-term care policies because they have a great financial advisor who had talked to them about this in years prior. And so when I sit down and meet with them, this is what their estate consists of. And what I would do is I would actually ask these questions, or I may even request that they fill out an asset intake form so we know what they have. But let's just say they have a primary residence of about $450,000 that's currently titled in husband and wife's name jointly. They have a beach house, $350,000 that's jointly owned as well. They have a bank account that has about $15,000 in it that's jointly owned. They have an investment account, $250,000. It's jointly owned. And then they have, each of them have an IRA. So husband's has $650,000 in it and wife's has $450,000 in it. So they have a combined gross estate of over $2 million, $2,115,000. Okay. So when I meet with them during the free initial consultation, we always offer free initial consultations. So when I meet with them, these are the concerns they express to me. So number 1, they want to create an estate plan that accounts for their blended families. And for that reason, wills can be problematic. Wills are problematic because it really comes down to the last man standing. And if you are a blended family and it's been a second marriage, you want to make sure that you're providing for your kids. The worst case scenario would be Mike dies and Carol, everything paid to her under the will, and Carol goes and updates her will and cuts out Mike's kids. And so wills can be problematic when we're dealing with a second marriage. So we want to make sure that we deal with that. We want to provide creditor protection for the children, and then we want to gift 10% of their estate to charity. They want to make sure they're tithing. I want to make sure to mention here that in the previous hypothetical, it was really focused on long-term care planning, so nursing home protection planning. This, we aren't focused on that. And the reason is because their financial advisor had counseled them years ago to have excellent long-term care policies. Now, that's not to say, like I discussed in the What's in Your Closet presentation, that's not to say that when you have long-term care policies, you wouldn't also want to use these irrevocable trusts to provide some protection, because they're actually used beautifully in conjunction with each other. Because there's a 5-year look-back period, the insurance can cover you through those 5 years, and then you have the protection of the trust. And especially if it's a hybrid product, then what you've been able to do is ensure there's a death benefit when the second spouse dies. So I do think that long-term care policies can be used in conjunction with the irrevocable trust. But let's just, to keep things simple, and since our last hypothetical already dealt with the irrevocable trust, that be a similar setup as this one. We're going to focus just on the asset protection for the next generation and the charitable bequest that we want to include. And that's just because in this example, again, fantastic financial advisor and the long-term care and policies provide really great protection. So we don't have to worry about that here. And so let's talk about what our office would recommend. Okay, so the first thing is that we want to make sure that we're talking to our client about the fact that charity as the beneficiary of their retirement might be a great way to do it. So if we know that the whole estate is a little over $2 million, we know what 10% of that is. So what we can do is we can say, what is 10% of 2 million? Figure out that amount. Okay, now that's important because when we're thinking about it, it's not going to be 10% of the retirement. Okay, it's going to be 10% of the whole estate. So I'm just looking here at my calculator. So let's say we have 2 million and we want 10%. That's 211,000, about $211,500. So when we're looking at our IRA money, this might be a great way to handle it, because what we could do is we could take, so it depends. Do they want it upon first spouse or second spouse? So what I would recommend is they might have the surviving spouse as primary beneficiary, and then as the contingent beneficiary, they might have something like, if it's the 450,000 one, if that's the one they decided to use, that might be, 50% of that account. So again, I know it's 50% of that specific retirement account, but you need it to be higher since it's supposed to be 10% of the entire estate. The other thing is that if you're going to use retirement to fulfill a charitable bequest, it does mean that you're going to want to meet with your advisor, your financial advisor, and your attorney annually to make sure that that percentage doesn't need to be adjusted. But the benefit is you don't have to adjust your will. Every year, just look at your beneficiaries and you may designate the percentages up or down depending on what your assets are doing, if they're either going up in value or declining in value. Okay. So I always like to recommend that. Why? Because retirement is actually subject to 2 different taxes. So it's not that it's taxed twice, because the rule is that different people can be taxed on the same asset. The same person can't have the same tax on the same asset. So what happens is it's subject to inheritance tax. So when the owner passes away, it's subject to inheritance tax or whatever the relationship is to the owner and the beneficiary. So if it's a child, it's 4.5. If it's a sibling who's the beneficiary, it's 12, and anyone else is 15. Spouse pays at 0%. So eventually, when it goes on to their kids, they're going to pay inheritance tax, which is 4.5 or whatever the fair market value is on the day the person dies, and it goes to them. Additionally, they're going to have to pay income tax as they draw money out of their retirement. So it's actually subject to 2 types of tax. It's subject to inheritance tax and income tax. So knowing that, that's why it's such a great thing to use retirement to go to charity, because charities aren't taxed. So what you're able to do is take the asset that would have been taxed, subject to inheritance tax and income tax, and get that to charity. And then all of the other assets can go to the kids. And that's only going to be subject to the inheritance tax. So that's why we look at it that way. So again, know that if your legal professional is recommending a higher percentage, it may be because it's supposed to be 10% of the estate, but we have to look at the value of the retirement. So it's actually 20 or 50% or whatever that is. So that's the first thing I wanted to make sure. The other thing is that when we're talking about, now let me switch to the actual visual, okay, so that we can make sure that we're understanding this. I did a visual for it. So make sure my screen here. Okay. So this is the visual that our office would put together for the clients. Okay, so we have the Michael and Carol Breeder Living Trust. So this is going to be a revocable trust. So unlike in hypothetical number 1, where we were using irrevocable trust, in this case, we're using a revocable trust. And that's because we're using a trust-based plan instead of a will-based plan. Like I said, because it's a second marriage, we're going to use a trust, because that way the surviving spouse can't make any changes to the estate plan like you can with a will. Okay? So the trustees initially during life are going to be Mike and Carol Brady. The successor trustees are going to be Greg and Marcia. And so what we did here, our recommendation was to take a child from either side. So we took Greg from Mike's children, and we took Marcia from Carol's children. That way we have the balance. So again, if we're doing a joint estate plan, we want to make sure that we are protecting both parties here. So we would make the successor trustee, we would recommend. Now, again, sometimes people say, no, I just want it to be Greg. I trust Greg. I think that's fine. But in this case, I at least want to have a conversation about a child from each family. From each, I should say, parent, not family. It's just a blended family. The reason why this is so important is that this trust is going to be irrevocable after the first death. So when the first spouse dies, no changes can be made to this estate plan. And that really makes sure that when we're doing an estate plan, we're protecting both husband and wife. If we transfer assets to this trust during their life, then there's no probate when they pass away. So again, when the second spouse dies, nobody has to go up to the courthouse, because if they transferred assets to the trust while they were living, then there's no probate. Again, we typically don't recommend a trust solely to avoid probate, but one of the benefits of using this trust for other reasons is that it does avoid probate. The other thing to know is that in trust, you can add nice transfer restrictions to the real estate. So if you want one child to have the option to purchase or the option to receive it, you can do that under the trust. Makes it easier than when it has to be in the estate, because then the estate has to remain open until that transaction completes. The other thing you can do is that when you're having it go to charity, you can have interval distributions for specific milestones. So when people graduate college, when they get married, a certain amount can go out to them. You can also have a different beneficiary or a different trustee, I should say, for a child in order to offer more creditor protection. I talked a little bit about this during the hypothetical number 1, but down here, when it goes in trust to the children, we do have the trustees as the children. You can always name a third party if you want to get some additional asset protection. So what this does is, because Marsha's serving as her own trustee for federal income tax purposes, we have to say health, education, maintenance, and support. Otherwise, it's included in her gross estate, federal state tax purposes. So if we include those magical words, whatever we leave Marsha in this trust is not included in her gross estate for tax purposes. So, but we can always make it that it's a third party. And if it's a third party, then it takes away the health, education, maintenance, and support standard, which means that Marsha would have long-term care protection if you want her to have that when you die. A lot of times what people will do is they may set it up initially so Marsha is her own trustee and give her the ability to appoint that third party, so that way she can have protection if she wants to. So we can also include long-term care trust for some protection. So generally, this is just explaining that they had good long-term care insurance, so we don't necessarily have to include it. But again, like I said, sometimes the long-term care insurance works great in conjunction with this. Okay. So what happens is if Mike and Carol transfer everything up into this trust, it's considered 50% Mike's in the trust and 50% Carol's. So let's say Mike dies first, okay? Carol's 50% drops down into here, into the survivor's trust. And remember, it becomes irrevocable, so she can't make changes to the entire estate plan, but her 50% drops down here. Mike's 50% goes through the administrative trust here. And what happens is Carol, along with a child, and in this case it might be Greg, because that was Mike's son, has either funded into the Q-tip trust or into the family trust. Now the reason why we have this is the Q-tip trust is included in the spouse's estate. So anything in the Q-tip trust does get a stepped-up basis. It is subject to inheritance tax. Anything that's put in the family trust, it is not going to get the stepped-up basis because it's not included in the surviving spouse's gross estate. Allow this for some federal estate tax planning if we would need to do that. But again, it would either be Mike's share of the assets would either go into the Q-tip trust or into the family trust. If it goes into the Q-tip trust, Q-tip stands for qualified terminable interest property, which just means whatever's in this trust qualifies for the unlimited marital deduction. So there's no federal estate tax on here. Right now we do have portability. So if Mike dies and doesn't use his exemption, Carol gets to add to hers. There might be some other tax reasons why you would want to either put in the Q-tip or the family trust. Okay. So again, it's either going to be in this trust or in this trust. You can put all or nothing. So you can put 100% in the Q-tip or 100% in the family. You can do 50-50. You can do 1/3 and 2/3, whatever you want to do. Carol and Greg would be the ones who would make this decision. And then what happens is it's held in the trust and the surviving spouse is benefiting, but it just means that that spouse cannot change this estate plan. And because it's a blended family, that's really important. Then what happens is when the second spouse dies, these three trusts go away and we have a trust for all of the beneficiaries here. And we might say upon the second spouse's death, 10% goes to charity and the rest is divided 50-50 to be divided among Mike and Carol's children. Okay. Now, if we have the 10% going to charity using non-probate assets, through the beneficiary designations on their retirement, we can put that in a trust. And we can say to the extent it's not satisfied through non-probate assets, then we would have the 10% go to charity. But if it's already satisfied through the retirement, then it's just divided among the kids and have it go in trust for each of the kids. That just protects it from their children's creditors. And so if it had gone outright to Marcia and then Marcia dies, Marcia's share would go according to her will, or if she doesn't have a will, according to Pennsylvania laws of intestacy. So by putting it in trust for her, we're able to say if she dies, money still left in here, her share goes on to her children. If she doesn't have children, her share gets divided to her surviving sister. So remember, this is because it's a blended family. So Carol wants 50% to be going to her kids. So Marcia, if she doesn't have kids, her share would be divided equally between Jan and Cindy's trust. Same thing over here. Peter would pass away, he has kids, his share goes to his kids, but if not, it goes back to Greg and Bobby. So it just allows our clients to be able to direct where they want the assets to go, which gives them some control and some protection. It allows them to provide for their charities if they would want to do that. So this is a different type of creditor protection. This is creditor protection for the next generation. So if Marcia receives it in trust, then it is protected against her creditors. Now, again, if we want protection is almost like a continuum. You can have maximum amount of protection. If you want the maximum amount of protection, you have to make sure you're naming someone other than Marcia as the trustee of her trust. And if Marcia is the beneficiary, just give the trustee the discretion to make distributions for whatever they think Marcia would need. If you have Marcia be her own trustee, it's like you're in the middle of that continuum. She has some protection, but not all the protection, because if she's her own trustee, she can make distributions for health, education, maintenance, and support, which would mean that her trust assets are available for child support and spousal support. So spousal support, if it would be awarded, is also available for long-term care. So if we want to make sure to protect it, we would name someone other than Marcia as the trustee. Okay? So here, it gives Marcia some control and some protection. And then the least amount of control would be for it to be distributed outright to her. She has no creditor protection. So in this case, how I would design a trust is we'd be in the middle. Marcia is serving as her own trustee, but as she gets older, she can appoint an independent trustee, and that would give her the maximum amount of protection. So that way, if she wants to, as she ages, get the maximum amount of credit protection, you can do that. But if mom and dad, if Mike and Carol decide they want her to get more protection or have 100% protection initially, they can just name someone other than her as the trustee. So again, this is designed to protect against a spouse changing the estate plan, because this trust does become irrevocable. It's designed to give us planning options for inheritance tax purposes, for stepped-up basis purposes, and it's designed to protect the next generation. So this is an example of a different type of protection. We're not protecting Mike and Carol using these trusts in their life because it's a revocable trust, but we are protecting when the first spouse dies. There's some protection against a change in the estate plan, and then we're protecting against the children. So again, this is just another example of a different type of asset protection planning. It's really for that next generation and for the spouse changing the estate plan. So I hope that this was helpful. I do recommend that you go back, if you haven't already, and listen to Hypothetical 1, because that's where I go into detail about those irrevocable trusts and how they can provide asset protection. If anybody watching either the What's in Your Closet video, the hypothetical number 1, or this hypothetical, if you have any questions, you're always welcome to reach out to me via phone, which is 717-655-2676. You're welcome to give me a call. And like I said, we're located at 20 East 6th Street and 206. We do offer free initial consultations. And so we're always happy. I block off an hour and a half to 2 hours on my schedule. And I'm always happy to meet with the advisor or the accountant and the client to go over these planning techniques and answer whatever questions. Our office does do flat fees. So we can meet with clients and their advisors or answer any telephone calls or any questions, and we don't bill for that. It's all built into the fees. So we always encourage questions. And like I did say in the last video, we do have a written plan that we put together along with a visual. And the written plan is designed to, in layman's terms, explain the provisions of the trust. Since the trust is thick and has a lot of legal language, it's just a brief summary but without using legal terminology. And then we do a corresponding visual. And we do take the extra step and we do also make recommendations for funding, whether it be beneficiary updates or whether it be retitling assets. So that would all be included in the plan as well. And then we do recommend that we meet with our clients at least annually. That allows us to update them on any changes in the law and allows our clients to update us on any changes in the law. So I hope this was helpful. Again, I just really wanted to try to get some information about different ways that you could protect assets using irrevocable trust, either while someone's living or when they pass away for that next generation. I'm here if you have any questions. And thank you so much for listening.